Good afternoon, ladies and gentlemen. I'm Professor Stuart Warner. I'm an associate professor of philosophy at Roosevelt University and director of the Montesquieu Forum. The Montesquieu Forum began in 2008. We're dedicated to studying the classical origins of the American founding. To say that we're nonpartisan would be a mistake because we're not involved in anything partisan at all. Our interest is entirely educational and philosophical. Over the course of the last 7 years, we've had conferences on and lectures on Tocqueville, Galileo, Shakespeare, Herodotus, Homer, Plato, Rousseau, Francis Bacon, Plato, lots and lots of Plato. We've had summer high school teachers' academies on the history of the American founding. We've had student reading groups. Our first lecture was held on October 27th, 2008, by Professor Ronna Berger of Tulane University, and she spoke on the subject of Moses as lawgiver. Now for Constitution Day, we return back to the subject of law. 4 years ago, the Provost's office asked us to direct the Constitution Day efforts of the university, and we began with a panel on what the Constitution means to me. Constitution Day might seem a mere formality, something not to be taken terribly seriously, something a shadow, something in the background. I think it's a most important day, a day to rethink what it means to live in a liberal constitutional democracy. The institutions of such, the ideas of such, are not biologically transmitted. They're only transmitted by ideas, by words, by books, by pamphlets, by articles, by conversation. Hence our event today. Institutions such as the Montesquieu Forum, of course, require a great deal of assistance, both financial and institutional. We're greatly indebted to the Jack Miller Center for the Study of America's Founding Principles in Philadelphia. They were our founding donor. We're also thankful to the John Templeton Foundation, the Brinson Foundation, the Northern Trust Bank, Art Wheel, an alum from California, and Al Harris, an attorney from Chicago, a close friend of the Montesquieu Forum, a close friend of mine, and he happens to be here today, so we thank him for his support. We not only need financial support, we especially need institutional support, and we have been graced over the years. The dean under whom the Montesquieu Forum began is Lynn Weiner of the College of Arts and Sciences, without whom we never would have been able to carry on the activities that we do. Our current dean, Bonnie Gunzenhauser, has supported us with an equal intensity. The chair of my department, Margaret Rung, chair of the History and Philosophy Department, has been just as supportive. But in addition to that, all of the staff who work at the university, the physical resources, people who set up the room like this, people who videograph our events, are all absolutely essential, and we're thankful to them as well. Our speaker today is Chief Judge Diane Wood, but before introducing her, I'd like to introduce someone else who is going to be extremely supportive of the Montesquieu Forum in every way possible, the new president of Roosevelt University, Ali Malikzadeh.
I should have prepared and brought my checkbook on that one, Stuart. Well, thank you, ladies and gentlemen, for being here. He has given me exactly 2 minutes. He knows I switched to Persian on the 3rd minute. So I brought 12 pages of material. so I have to read it very quickly. But joking aside, we are honored to have you here. You're here to hear an amazing story about due process, and just, in the next week or two, think and listen how many times you're going to hear that phrase. And also in a negative way, how often we're going to hear that about other countries and about the rest of the world. I will mention this to you, that Judge Wood also is the chair of the Council of the American Academy of Arts and Sciences, and they produced a report regarding the vital role of research in preserving the American dream. Now, as you know, Stuart and Lynn Weiner are leading an effort for Roosevelt University for us to have an annual event here, a major conference to showcase the faculty. Many of you are here, your good work, and your intellectual capital and your research under the banner of the American dream, so that we can continue to have that discussion, and for the world and our country and everybody to come here and talk about American dream and rejuvenating and reimagining the American dream. So with that said, I'll leave the podium, and thank you so much.
Chief Judge Diane Wood is, not to put too fine a point on it, a pain in the neck to have to introduce. What does one say about someone of such extraordinary achievement for whom the day is not 24 hours long, but 28 or 30 hours long, given the things she's able to accomplish? She was born in New Jersey, something, of course, close to the heart of someone who was born just across the river in Brooklyn. At the age of 16, her father, who was an accountant for Exxon, relocated to Houston, Texas. She went to Westchester High School, where she was the #1 student in the class, period, and especially the #1 student in the class in physics. She wanted to invert the advice of Horace Greeley upon graduating high school and go east, young woman, but financial exigencies got in the way, and she stayed at home in the state of Texas and attended the University of Texas at Austin, where she registered in what's called the Plan 2 Honors College. How such a prestigious college came up with such an attractive name, Plan 2 Honors College, I'm not sure, but it did lead her to take 1 year of world literature. It led her to take 1 year of philosophy. She learned, presumably, many practical skills. She majored in English literature, and upon graduating, had her heart set on truly heading east, and she applied and was accepted to Yale University to study comparative literature. Not long before beginning Yale, she began to read some of the comparative literary journals and decided that whatever she might write in the future, perhaps very few people would read it, and wanted to make a deeper imprint upon the world. So she decided to go to law school and to go to the same institution from which she had gotten her undergraduate degree. She went to University of Texas Law School, public schools all of the way. Is it Hook'em Horns? Are you? Hook'em Horns. She's a very proud alum of her universities. Upon graduating from the University of Texas Law School, she clerked for the Fifth Circuit Court Judge Irving Goldberg, and following that, she clerked for the Associate Justice of the United States Supreme Court, Harry Blackmun. She clerked for him only 3 years after Blackmun had written the majority opinion in Roe v. Wade. So this was a very heady time in American law. Following that, she worked for, and here is a litany of extraordinary accomplishments, she worked for the State Department. She worked in private litigation. She worked for the United States Department of Justice. Finally, she wound up at the Georgetown University Law Center. And not long into that position, she received a call from the Dean of the University of Chicago Law School, Gerhard Casper. This, in a certain way, has some bearing on today's event because Gerhard Casper has a reputation, perhaps for many things, but one thing in particular. He's never without a Constitution in his breast pocket. I was told even his bathrobe has a copy of the Constitution in it. She came to the University of Chicago as a professor of law, and it was through that medium that I first heard the name Diane Wood, because my wife was a student of Diane Wood, and she was taking antitrust with her. And since I had some designs, and I hope my wife to be at some designs, on monopolistic practices in relationship to each other, antitrust seemed to be a very important subject. And I remember during that year very distinctly, because my wife is not at all prone to hyperbole, she said, and I quote, "She's really smart." And indeed, she turns out to be. Eventually, she became Associate Dean of the law school, and then she was named by President Clinton 20 years ago to the Seventh Circuit Court of Appeals. And it was just 2 years ago, in 2013, that she was chosen to be chair of the court. And the decisions she has written are, of course, important. The articles that she has written are, of course, important. What strikes me is how lucky she was. What would her life have been like had her father not relocated to Houston? Would she have found the University of Texas? What would her life have been like what would our lives have been like had she attended Yale in comparative literature? Would her contribution to the world have been the same? I mean, in a certain way, her life is all of our lives. It's bordering fortune on the one hand and deliberation on the other hand. We luck into circumstances, but we reflect deliberatively about the choices that life gives us. In a certain way, that's law. Law has to provide certainty for our actions, provide for reasonable expectations. But the world is always and everywhere wacky, and it's a mess. And to be able to deliberate and solve questions having to do with the necessities of life and the contingencies of life, that's law's task. It bears on questions having to do with due process, and it bears on questions having to do with the Magna Carta and the idea of due process, the title of her talk this afternoon. Would you please all join me in welcoming Diane Wood to the Montesquieu Forum?
Well, thank you very much, Stuart, for that very lovely and exaggerated introduction. I can't resist, since you have mentioned Gerhard Casper's copy of the Constitution, to tell you all a very brief anecdote about that. I was in Philadelphia probably about 6 years ago with Gerhard for an annual meeting of the American Law Institute, which I also do work with. And Gerhard and I had dinner together, and we were very old friends at this point. And I was going to go back to my hotel, and Gerhard insisted on walking me back to the hotel, and I poo-pooed him. I said, "Oh, Gerhard, don't be silly. You know, I can get back to the hotel fine." No, no, no. I mean, Gerhard, the perfect gentleman, walks me back to the hotel. The next morning, I come over to the meeting, and one person said to me, "It's all your fault." And I thought, what's my fault? I mean, I don't know what happened. Well, it turns out that walking back to his own hotel from mine, Gerhard was assaulted by somebody. A person leapt out of a bush and hurt him, actually, you know, not terribly or anything, but banged him up. And the person also stole some things from Gerhard. Now, what the person probably thought was that he was stealing Gerhard's wallet. What he in fact stole was Gerhard's copy of the Constitution. So I believe it was a disappointed thief, but he probably got what was coming to him in more ways than one. So I'm very glad to see that the spirit of the laws is alive and well at Roosevelt University, and that there's a forum named for Montesquieu. And I was also delighted to receive this invitation to talk about Magna Carta. As I'm sure you all know, this is the 800th anniversary of the sealing of the Magna Carta, which, give or take, there's some historical debate, occurred approximately the 15th of June in 1215 on the fields at Runnymede, fields which I have visited personally twice within the last 4 months, believe it or not. But 800 is a good round number, a good time to think about what this document means. I am confident that no one on the fields of Runnymede in that June could have imagined that the document they were considering would be the subject of intense public scrutiny 800 years later, or that scholars or the public at large would be convening actually all over the world to consider the contributions that it made to our legal system, and actually what its contributions might be going forward. In fact, the very instant he put his seal on the charter, King John was planning to get rid of it as soon as he possibly could. And why did he think he could do that? Because he had fairly recently made peace with Innocent III, the Pope, after a great contretemps about who the Archbishop of Canterbury was going to be. And John had acquiesced to the choice of the Pope, Stephen Langton, and so everything was wonderful again. England wasn't excommunicated anymore. All was well. So John expected that the Pope would reward that capitulation, and indeed Innocent III did so when he issued his papal bull on the 24th of August, 1215, just 10 weeks later. The papal bull utterly rejected and condemned Magna Carta and ordered the king, in fact, not to observe it, and John was only too happy to oblige. History, though, was not on either John's side or Innocent III's side. None of us is here to celebrate August the 24th as the date when royal prerogative and papal power were restored, although actually I realize the Pope is in Washington today. I tried calling the administrative office of the U.S. courts, and I found out that they're all working at home because the traffic in D.C. is probably impossible. But in any event, back in 1215, this was actually what Innocent III was trying to do. Instead, what has happened is, in a way, what Stuart was just saying, partly through accident, partly through design, is first the English kings, then English scholars, in particular Sir Edward Coke and William Blackstone, and ultimately the world, reaffirmed what came to be understood as the core principles of Magna Carta, and took them as inspiration for the rule of law. At the heart of those principles is the concept to which we now refer usually as due process, especially in this country. Chapters 39 and 40 of the original 1215 Magna Carta reflect this principle. And even if they did not originate the idea, which they didn't, Magna Carta itself has some antecedents, it was Magna Carta to which generation after generation turned for legitimacy, for guidance, for inspiration. So I'm just going to read them to you. They're extremely short, so you'll see what we're talking about. Chapter 30 in English translation, this is of course a Latin document, but in English translation, chapter 30 says, "No free man shall be taken, imprisoned, decised, outlawed, banished, or in any way destroyed, nor will we proceed against or prosecute him except by the lawful judgment of his peers and by the law of the land." So that's chapter 39. Chapter 40 says, "To no one will we sell, to none will we deny or delay right or justice." All right, these are pretty broad statements. And I would suggest no less powerful because they occur in a document that addressed only the concerns of an elite and that included many other provisions that seem quaint or trivial or entirely irrelevant to modern eyes. And I'm not being unfair to the document when I say that. If you skim through the original 1215 Magna Carta, or there was a revised version in 1225, you'll see that it's chock full of provisions that are grist for legal historians, but that would either baffle or bore most others. So, why are we worrying about it? Well, what am I talking about? Chapter 6 of Magna Carta says, "The king is not to grant to any baron the right to take an aid from his free men, except to ransom his person, to knight his firstborn son, and to marry once his firstborn daughter." Several chapters discuss the proper amercements, sort of a word for fines, for small offenses. So no township is to be amerced for making bridges over rivers unless they used rightfully to be there of old. There's lots of talk about decisement, taking away your property, holdings by fee farm, which was a type of land tenure, holdings by socage or burgages, and these are all things we really don't have anymore. And at least these are the parts that are non-offensive. There are a couple of chapters that set out special rules for people who are indebted to Jews. Chapter 50 entirely removes from their bailiwicks the relatives of certain specified men and, quote, "the whole brood of the same," close quote. So no contemporary judge is taking any inspiration from that part. So why are we doing this? I'm reminded very much of the Declaration of Independence when I ask myself that question. Much of the Declaration is the same sort of thing. It deals with the concerns of a world that has long since passed. Jefferson and all the people who signed the Declaration wrote it, as they said, out of a decent respect to the opinions of mankind, to declare the causes that impelled them to the separation from their sovereign. So a great deal of the Declaration, if you go back and read it, enumerates the colonists' grievances against King George III. Typical complaints include the summoning of legislative bodies to inconvenient places, making it difficult for foreigners to naturalize, and one of my personal favorites, quote, "erecting a multitude of new offices and sending hither swarms of officers to harass our people and eat out their substance," close quote. So again, we aren't really worrying about that vis-a-vis the English or anyone else today. But what do we remember? We remember the soaring statements in the second paragraph. We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. So Magna Carta is really the same. Although most of it has faded over the centuries, critical parts of it have more than stood the test of time. I would like to think that the rule of law as we know it today would have come about eventually, whether or not the rebellious barons cornered King John at Runnymede. But who knows? It's very hard to say. I don't know if you're fans of those books that get published, like the what-ifs of history. What if something happened? What if somebody didn't get sick? But it's very hard to say. This is what happened, and those barons were the ones who extracted the charter from him. And without meaning to, I'm sure, they laid the cornerstone for our modern concept of due process and more broadly, the rule of law. So let's turn to this. First of all, I want to make a point about the kind of fragility of the charter. It wasn't at all clear that it was going to last. As I said, only 10 weeks later, the Pope eliminated it. And if you happen to be lucky enough to go to the British Library, to their treasures room in London, you'll see copies of the original charter, copies of the papal bull, copies of other things. But when Innocent III did that, the barons said, fine, back to war we go. So they began fighting again, and war went on for a while until October of 1216, when John dies, perhaps of dysentery, perhaps dysentery assisted by something else, who knows, but he does die on October the 18th, leaving his 9-year-old son, who now is Henry III, as his heir. 9 years old, Henry's obviously too young to rule on his own, and so he needs regents. And those regents are eager to win support for the boy king, and so what do? They reissue Magna Carta knowing that the barons who wanted Magna Carta in the first place are likely to rally around this new version of it. It's actually very interesting, too. When they reissued it, they deleted the provisions of the 1215 document that created some sort of enforcement mechanism for all of these promises. So they changed it from something that really looked like it was trying to be a serious document to something that was more aspirational. Yet another revision comes out in 1217. When Henry reaches majority in 1225, he issues a further revision, and the 1225 version winds up in the statute books at the end of that century in 1297. And the 1225 version kind of consolidates the old chapters 39 and 40 into a new chapter 29. So sometimes you'll see chapter 29 cited as the source of all of the things that we're talking about. So Magna Carta promises that no one will suffer a deprivation. It even actually refers occasionally to women, although not really too often, save by lawful judgment of his peers or by the law of the land, not selling or denying or delaying justice. Compare then, jumping forward first to 1791, the Fifth Amendment to the United States Constitution. The Fifth Amendment includes the due process clause that applies to the federal government. Then later on in 1868, we get the due process clause that applies to the states, but it's about the same. So the due process clause says, no person shall be deprived of life, liberty, or property without due process of law. Well, if we're thinking about whether Magna Carta really had anything to do with this, the first thing we need to do is figure out what did Magna Carta mean when it was talking about the law of the land or no deprivations without the judgment of your peers. So it turns out that there are ambiguities there, and there are also ambiguities in the idea of due process. So let me talk about a few of those. One debate is what's the right translation of Chapter 39? The phrase in question, and you'll pardon my Latin, is nisi per legale judicum parium suorum vel per legem terrae. And it might mean, the vel is the tricky word, as people argue. It might mean unless by the lawful judgment of his peers or by the law of the land. So you're okay if your peers think it's all right, or you can apply the law of the land, or it might mean and. It might be conjunctive. And so people have been debating that for a long time. Another question is, what are we trying to say with the law of the land? As long as Parliament passed it, does that count that it's a law? Does it mean law of the land also encompasses the results of judicial decisions? Does law of the land mean the writs that were issued by the chancellor to support the king's justice? And if it does, remember that the writs not only created a procedure, say, for an action on debt or an action of covenant or an action of trespass or any other kind of action they had, but it was actually also a substantive source of law. So we're not really sure what the law of the land means. And in particular, we're not sure if there is some limit on the power of the lawmaker. So the question arises by the time of Sir Edward Coke, can an unjust law count as law of the land? Coke thought not. He was writing an opinion about a statute that authorized the Royal College of Physicians to fine and imprison persons practicing medicine without a license, and to take a share, on top of that, of the fines they collected. So even the bar, with its unauthorized practice of law rules, isn't quite that bad these days. But what Coke wrote in deciding that case was this. He wrote, when an act of Parliament is against common right and reason, the common law will adjudge such act to be void. That's a very ambitious statement for a judge to make, especially a judge in the English system where Parliament is understood to be the supreme power. But it does give the idea that if Parliament were to pass some extremely unjust law, maybe the judges don't need to enforce it, and maybe that gets all the way back to Magna Carta. So another question is whether it's actually accurate, as even Coke did, to equate the phrase law of the land to due process of law. If law of the land is a very narrow phrase, then you're probably not being faithful to the original meaning. But then due process is another highly contested phrase in the law. So let me talk to you about that just a little bit. American lawyers would tell you that when you look at the due process clauses, the Fifth Amendment, 14th Amendment due process clauses, they might be referring to one of two different things. They might be referring to procedural due process, a regularity in the way the government goes about adjudicating your rights. Both the federal government and the state government are obliged to give people procedural due process, and the content is fairly well understood. Above all, the judge or the other adjudicator has to be impartial. So the Supreme Court has had cases in which the judge, actually this is just some traffic court thing, but it was an important principle. The judge was paid out of the traffic fines he imposed. So if you were found to have violated the traffic laws, the judge got money, and if you were not found to have violated the traffic laws, the judge got nothing. And the Supreme Court said back in the 1920s, no, 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 that will not do. That does not give you an impartial adjudicator. The court has also held, and this is hardly shocking, that if the judge is a relative of one of the litigants, that won't do either. The judge is not permitted to have a financial stake of other types. You know, if there's a case pending before me and it involves the University of Chicago, I'm not allowed to hear the case. I teach at the University of Chicago still, and I have too much of an interest in it. So the idea of an impartial adjudicator is very, very firmly fixed in our notion of procedural due process. In addition, beyond getting the right adjudicator, there are other things that go along with it. Most importantly, notice of what it is the government thinks you've been doing. You have to be told what's at stake, and an opportunity to be heard. And it has to be a meaningful opportunity to be heard, and it has to be meaningful notice. So the Supreme Court has considered cases, and the lower courts have also, of, you know, suppose the notice goes to somebody in a language that the person doesn't understand at all. Does that count? I mean, maybe the person doesn't have the faintest idea that they're being summoned to a court. What if the notice says the hearing is starting in 15 minutes down in Peoria, and here we are in Chicago? Well, that's not effective notice. You can't possibly get down to Peoria in 15 minutes. So the opportunity to be heard has to be meaningful, and the notice has to be meaningful. And beyond that, the court has taken a fairly flexible approach. It balances things. It balances the private interest that would be affected, what's the risk of an erroneous decision, what's the government's interest, how burdensome would additional procedures be. And so the procedures vary. You're going to get one set of procedures for a traffic ticket. You might get another set of procedures. In fact, you would get another set of procedures if you were accused of robbing a bank, and you might have yet another set of procedures if it was a civil case. So that's kind of the procedural dimension of due process. What's the other side? The other side is called substantive due process in U.S. case law. Some people accuse that of being an oxymoron, because they don't see how substantive and process can live happily together in the same phrase. I am not one of those people, even though I'm not going to tell you the phrase itself is the most felicitous way that you could express this concept. But this is what the Supreme Court, and actually a fairly recent Supreme Court, it's a 1998 decision about a high-speed chase, actually. But they said, the provision that no state shall deprive any person of life, liberty, or property without due process of law guarantees more than fair process. It covers a substantive sphere as well, barring certain government actions regardless of the fairness of the procedures used to implement them. So that harks back very much to the idea that the law of the land needs to be a just law. It's a very powerful idea. So the court has said, for instance, that no amount of procedure can be used to justify certain things. For example, it doesn't matter how much procedure they give you, the state is simply not entitled to pass a law telling you who you must marry or who you may not marry. Now, we know from the decision just this June that the most recent application of that deals with same-sex marriage, but that rested in turn on the decision of Loving versus Virginia from the 1960s, in which the court struck down a Virginia law that banned interracial marriage. This is not about procedure. You can't save that by procedure. Another very old application of this idea is no amount of procedure will allow you to be restricted in the choice of the language you want to teach your child. We wouldn't think of that as such a hot-button issue, but it was at that time. No amount of process, in a case actually that was before the court the term I was clerking there, is going to save a local ordinance that forbade a grandmother from having her 2 grandsons living in her home. The reason the ordinance did that is that the 2 boys were each sons of her different sons, so they were cousins. If they'd both been sons of the same son, they could have lived there, but they were cousins, and so she was actually criminally prosecuted for having more than one family in her house. And the court said, you can't do that. This violates substantive due process. There is simply a realm that government cannot intrude in. So this principle applies whether you're talking about executive action or liberty action. And the court has said things like the liberty protected by the Due Process Clause denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home and bring up children, to worship God according to the dictates of your own conscience, and generally to enjoy, as they said, those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So this has been a theme throughout, certainly starting at the beginning of the 20th century, and it's a difficult doctrine, no doubt, but it's one that is very firmly established in due process jurisprudence. One of the themes the court focuses on is the inappropriateness of arbitrary legislative action, and that message, too, can trace itself very quickly back to Magna Carta. At the same time, we all recognize that courts cannot be free-roving councils of revision, able to strike down any law that doesn't suit an individual judge. That would be unacceptable in a democracy. No judge thinks that's what the law is, and so thus the power to rein in the actions of a democratically elected legislature is not something that can be lightly used. That's why, for example, in 1997, when a group of terminally ill people sued and wanted the court to say that there was a substantive due process right to physician-assisted suicide, the court said, no, this is just not well established enough. It's not deeply rooted in our nation's history and traditions. It's not implicit in the concept of ordered liberty. Whatever the phrase you like, they used all of those phrases. And so they said, this is a question that needs to be left to the democratic process. So obviously I'm not a time traveler, and I can't say for sure what the barons expected the courts of their own time to do. But Magna Carta, and particularly chapters 39 and 40, do launch all of these ideas. And they actually, interestingly, once you finish the ebbs and flows of Magna Carta in England, and that really comes to a head with the Stuarts. The Stuarts were big fans of royal prerogative, and so they were not big fans of Magna Carta. But after, a beheading and a civil war and other things that were most unfortunate that happened then, the UK winds up, with the constitutional monarchy and democracy that we recognize today. And at the same time, it's very interesting, as North America is being settled by English settlers in particular, they turn every lawyer and a lot of educated people had Cook's writings on their bookshelves. They had Blackstone on their bookshelves. So it was really through that medium that Magna Carta comes to the United States and becomes embedded in our own legal culture, our own legal thinking. And in fact, it's funny, if you go to Runnymede, you will see that there's now an interesting sculpture of 12 chairs that has just been unveiled as of June 15th of this year. But the memorial that's been there much longer is one established by the American Bar Association. And the English are a little bemused by this, that it's the Americans that have made the bigger fuss about the 800th anniversary. But I think it's because since our country was founded so much on ideas, it wasn't founded on ethnicities, it wasn't founded on geography so much, it was founded on the concepts expressed in the Declaration of Independence, later expressed in the Constitution. The concept of not being deprived of your rights other than by the law of the land was a very powerful one to the American settlers, and one that they wanted to carry forward in their own founding documents. And in fact, they took it and ran with it, and it has now shown up actually at a global level. If you look, for example, at the Universal Declaration of Human Rights, which you'll remember Eleanor Roosevelt was very instrumental in bringing about, it says in Article 8, everyone has the right to an effective remedy by the competent national authorities for acts violating fundamental rights. It bars various kinds of arbitrary action. You see the same thing in the International Covenant on Civil and Political Rights, another UN document from some years later. The United States is a signatory to that document, as are almost every country in the world. And they call for effective remedies for persons whose rights and freedoms have been violated, for equality before the law, and so on. So the concept that the state cannot deprive persons of life, liberty, or property other than by the rule of law, and that the rule of law itself has a substantive component, has actually become a worldwide concept. The only potential fly in the ointment that I have been complaining about of late is this: the commitment by a state to act only in accordance with the law of the land or according to the rule of law is empty if the state gives no way for affected individuals to enforce that commitment. Courts need to be open, and judges need to be independent to ensure that these promises are kept. And that means that you need to have some kind of remedy. Even John was doing this by putting his seal on Magna Carta and agreeing, as he did in the 1215 document, to a council of 25 barons who would review his compliance with the charter. He understood that somebody outside the sovereign, so to speak, needs to be looking at this. So a couple of years ago, actually maybe a year and so ago, I contributed a chapter to the book that the American Bar Association published about Magna Carta. It's just called Magna Carta and the Rule of Law, 2014 book. And Danielle Evans, a former law clerk of mine, and I explored the idea of the compatibility of Magna Carta with our current doctrine of sovereign immunity. For the non-lawyers in the room, sovereign immunity means exactly what you probably think it means. It means that you are not allowed to sue the state in a court. The United States follows the doctrine of sovereign immunity, and then it has lots of exceptions. So if you're complaining about a tort, that some postal truck runs into you or some other kind of tort, there's a Federal Tort Claims Act that permits lots of lawsuits, although not an unlimited number. There's another waiver of sovereign immunity for contract suits. So if you're a government contractor selling, selling food packages to the Pentagon and they don't pay the bill, you can go sue in court. So they've waived their sovereign immunity. But the government's very insistent that the only reason that suit can go forward is because there's a waiver. And so a court would always have to look to see if the lawsuit is within the scope of the waiver. The same thing is true for states. The same thing is true for Indian tribes. The same thing is true for foreign governments. So here's this weird doctrine of sovereign immunity. And we need to see how does that fit within this idea that no person, not even the king, is above the law. I think it's an awkward fit myself. It's very hard to justify why the government should insulate itself from accountability. So, you know, and every time they assert sovereign immunity. I mean, there's a case that I remember where the University of Wisconsin, which is a state institution, was allegedly infringing somebody's trademarks. Well, you can't sue them. They're entitled to sovereign immunity, and so they can just infringe if they want to. And you begin to see how broad this is to the extent that state entities own patents, they own trademarks, you know, for that. They don't have to answer for age discrimination, they don't have to answer for disability discrimination because they have sovereign immunity. And so my question is why? You know, why is that the right rule? I understand that it is the rule, but why is it the right rule? And why is that compatible with these broad ideas that Magna Carta launched and that have in many ways been incorporated into U.S. law? So it seems to me it's worth careful thought to see if the doctrine of sovereign immunity either should just be thrown out the window. Some people have argued that that's really the only thing you can do with it, or perhaps maybe just scaled back so that sovereign immunity does not apply, for example, to commercial activities of state or federal or any level of government. That's the way we treat foreign sovereigns, by the way. We give them sovereign immunity for their governmental acts, but not for their commercial acts. I don't think that either the state or the federal governments would have a huge deal to complain about if we did scale back sovereign immunity, although I realize that it would drive up their litigation costs a certain amount, but you know, those are no different from the costs that private parties incur. But basically their track record is reasonably good. They would win most cases. And you know, maybe sovereign immunity is just a medieval holdover from those periods when Magna Carta was at an ebb, and we should really think about the reason why we are not calling government to account. Now there's another field as well in which we are as a society groping to see how we can create a government that's as accountable as many think it should be, and that's in the area of secret government operations. You've been seeing questions about the Foreign Intelligence Surveillance Court, which is the court that authorizes surveillance for purposes of anti-terrorism activities. We all understand that, you know, you can't put on the front page of the New York Times what you're finding out from essentially spying, right? And that we need some kind of check on that. But in the wake of Snowden, in the wake of other things, there have been allegations that are very troubling about the scope of the surveillance. And we have very few tools in our toolbox right now to assure ourselves that that scope is proper. The Supreme Court, in a case called Clapper against Amnesty International, refused to allow people who claimed that their phone calls to foreign countries had been collected. There's some question whether they were actually listening or whether they were just keeping track of all the phone numbers you called and all the people who called the people who you called. I mean, pretty much you get the whole world pretty soon. But we don't have good tools for that. And so you could ask, is that also compatible? Is there some obligation, if we're going to be living under the rule of law, to come up with better safeguards than the ones that we have? I think better safeguards are possible, and we are about to experiment with some sort of third party who might be able to challenge the need for a warrant. In the United Kingdom, I learned recently, they have a system of special advocates who can appear before the equivalent tribunal there, which is called the Investigatory Powers Tribunal, and something like that may be possible, which would keep secret that which needs to stay secret and understand the government's interest, but also put the individual's interest back into the balance to a somewhat greater degree than it has been. We have managed this before. We've seen the rule of law upheld in many difficult situations. You may remember the Pentagon Papers case if you're old enough, and if you're not old enough, it's just a case where during the middle of the Vietnam War, the New York Times got a hold of some sensitive documents. They published them, and the world didn't come to an end, and the court handled it in an orderly way. You can think back again to that same era when the special prosecutor wanted to obtain the secret tapes that then President Nixon had created. He claimed that, again, the country would collapse, but the tapes were turned over, and it didn't. President Bill Clinton said, oh my gosh, you know, if you move forward with this, with the Jones litigation, you know, I won't be able to be president effectively anymore. The Supreme Court said no. They famously underestimated how much disruption it was going to cause, but they said the rule of law applies to everybody. It applies to presidents. It applies to ordinary people, too. And other things can challenge the rule of law. New Orleans had some very significant problems after Hurricane Katrina. New York had difficulties after Superstorm Sandy, and on the whole, we have done pretty well with this. So let me just wrap up and say, you know, we are very committed to the rule of law, and Magna Carta is one of those things that has inspired this commitment on the part of the United States. Many people have said, at this point, nothing is really left of it. It's just a myth, even though maybe it's a nice myth. And I think that's not quite fair. I think of it more as a seed. And it's a seed that took root, especially 39 and 40, grew, changed its outward appearance, but it is still living today. Beyond that, I would say, what's wrong with myths? Myths are great. I like myths. And it's hard to assign an objective value to a symbol, but every country needs symbols. Every people needs symbols. They're the embodiment of our better selves, and their power can keep people going through tougher times. They remind people of the goal, even if it's only imperfectly achieved. And they provide a measure of success or failure when you look at the smaller steps. Magna Carta represents the fact that arbitrary power can be opposed. It represents the fact that people can work toward fair rules. And it represents the fact that temporary setbacks can be overcome. So the final message that I take from it is the need for eternal vigilance. We saw how quickly John set it aside, and then, by chance, it comes back in. So we need to be just as careful with respect to our own commitments to due process and the rule of law to ensure that difficult times don't cause us to lose our commitment to it. Justice O'Connor wrote a foreword in the ABA's book in which she said, the Charter continues to serve as a beacon for those committed to the rule of law and to the idea that even the highest powers in government must stay within its boundaries. So I think that's right, and I think in situations of difficulty, Magna Carta gives us the courage to go on, shows us the way, and I hope in 200 years our successors are celebrating its millennium. So thank you very much. Yes, ma'am. Oh, sorry. Maybe.
Judge Wood, how would you differentiate the due process clause in the Fifth Amendment from the due process clause in the 14th Amendment? And do you think that the due process clause of the 14th Amendment has more latitude because of its substantive quality than the due process clause in the Fifth Amendment?
It's difficult to distinguish between the two based just on the language on the page. So that's where I would start. Obviously, the 14th Amendment embeds the due process clause in a longer list of other things that it's talking about, including the Equal Protection Clause, which is cheek by jowl with the due process clause. So I've seen different views of this. I mean, some people, and actually the Supreme Court does not seem to understand them to be very different at all, although they have said that the Fifth Amendment due process clause has an equal protection component, which is very interesting. That was what led in the companion case to Brown versus Board of Education in 1954, Bolling versus Sharp, the court to say that the schools of the District of Columbia were under the same rule as the schools in Kansas and the other states in the consolidated case. So in that sense, you would say, well, maybe the Fifth Amendment clause is a little broader because the 14th Amendment covers these things separately. Other scholars whose work I've read suggest, no, it's actually the 14th Amendment due process clause that is potentially broader and that has more of a substantive component, and they look to the drafting history, they look to the kinds of problems it was supposed to solve, they look to the fact that there's Section 5 of the 14th Amendment, which allows Congress to enforce the promises of the whole amendment, actually, not just the due process clause separately. So, I mean, my answer as a judge is I don't see much other than the fact that there's an equal protection component that would allow me to read them very differently, and the Supreme Court hasn't done that yet. As a scholar, perhaps, you know, maybe it is the 14th Amendment that's a little broader.
A naughty question. Do you see litigation fees impinging upon due process for many Americans today?
Well, it's very interesting that you would ask that. I just got back last week from the semi-annual meeting of the Judicial Conference of the United States, which I sit on because I'm Chief Judge. That's the Chief Justice chairs it, and the 13 Chief Judges and 13 District Judges. And one of the things we talk about a lot is the cost of access to the courts, and our very deep concern that the cost of access to the courts is undermining very much the promise, if you will, of equal justice under law, to take the phrase on the Supreme Court building, or the right of people to seek redress for whatever it is that's happened to them. It's a very serious problem. We have amendments to the Federal Rules of Civil Procedure that are about to take effect. And I've talked to many state Supreme Court justices as well, who actually preside over the most important legal systems in the country, since in excess of 90% of litigation happens in the state courts. And they're the courts that offer small claims courts, for example. They're the courts that offer more informal procedures for people who may not have earth-shattering problems, but they're important for those people. They want their, you know, deposit back from their lease, or they want something, and it means something to them. So we have a long way to go, but I think it is a real problem.
The existence of the internet poses new challenges to the concept of due process. Are there limitations on your ability or the ability of your clerks to go out on the internet in deciding a case and develop new information?
I'm assuming that you've read Roe versus Gibson. There's a recent case by my colleague Richard Posner in which Judge Rovner concurs and Judge Hamilton dissents because Judge Hamilton thinks that Judge Posner did too much internet research. I think it would be a mistake to put it in its own category, because the truth is, before there was an internet, Judge Posner was probably reading a lot of books and magazines too, and doing whatever research. What I always look at is I just try to make sure that any outside material I may find when I'm researching an opinion is not the kind of thing that the other side would have any reason to think that they needed to respond to. So if I see the letters GERD, and I go to the internet and I see that that means gastroesophageal reflux disorder, I'm not doing anything that anybody's going to care about. That's just a definition. If I start getting into, you know, further and further details about it, maybe in our adversary system, you need to send it back for more process. Although the interesting thing about that case is that's exactly what it did. It just said, don't throw it away based on the papers. Let's have a full trial. And so Judge Posner's outcome was the one that favored more access and more process, not less. And the other side will have plenty of opportunity to say whatever they want to say in that case. But the internet is awfully easy to research on. I'll grant you that.
Yeah, thank you for the talk. I'm not still not sure what exactly the root of it is, and maybe you say it's somehow supposed to be hazy and have a number of concerns reflected in it. I mean, one thing about 39, is it Article 39 or Chapter 39?
I mean, it's just brackets 39. I don't think there was a 39 in it.
Sentence or whatever.
Right.
I'm not sure I'm happy with either. The legal judgment of my peers, you pointed all this out, that could be incorrect, because the law can be unjust and my peers can be malicious or stupid, or the law of the land, which could also be bad. So in a way, it doesn't offer protection as such. But maybe it's not about that. It's about what justice is. It seems that's the fundamental question. So we have to go back and read Plato and to see to learn what justice is, or do we fashion the idea of justice? And then I remember two things which seem like something like due process. One was a biblical example. Maybe I can mention them just as a way of thinking whether that's different from the egalitarian due process or more modern due process. I'm not sure. I don't know where in the Bible, but there's a Jezreelite Naboth. He goes to and then it was the other way. Goes to Ahab. Yeah, I think he's good. And he says, "I'm going to take your vineyard because I like it, but I'm going to give you a better one." Or, if you like, actually, it's not. I'm not sure what it is. I'm going to give you the money for it, for the better one or for the first one. I'm not sure. Anyway, it sounds fair. Ahab says no, and then the wife of Naboth, I think, kills the guy, and he should have taken the deal. But there's some kind of instinct on the part of Naboth to offer, seems like some kind of justice, due process. And then I noticed in Montesquieu, the chapter 25, book 25, book 26, chapter 15, which is supposed to be a comment on due process, and he cites a 13th century French jurisprudential scholar who says there are these, sometimes the roads deteriorate and we have to open up new roads, but then we have to take over someone's house. Mm-hmm. That postdates the Magna Carta, and I think that's just by a few decades. But what we do is people who've benefited from the new road give some money to those whose houses were taken to make the new road, and somehow that's, I don't know. Both of these have a different flavor, but they're not about. I'm not sure. Maybe there's a different understanding of justice. Somehow there's due process, or maybe something more substantive that is not arbitrary. I guess last rambling comment. I mean, the very idea of non-arbitrariness. I was just today at a consulate, and someone said, "Well, the guy at the border won't be arbitrary. There's an unreasonable, obscure law which the Border Patrol can cite, and it's not arbitrary because it's based on law. But if the law is unjust or unreasonable, it's due process could be a vehicle of injustice."
Well, yeah, let me just offer a couple of thoughts on that. First of all, law of the land. I do think in the minds of the barons, it was to tell the king, you can't just decide to do this. It's got to come from another source. Now, of course, as of 1215, there isn't a parliament as we know it. That doesn't come until later that century, maybe 1264 or so. So law of the land probably means, among other things, what the king's courts have announced to be the common law. That's what common means. It means common to all of England and something that makes its way into the king's courts. So I think they were talking about some sort of reference. And then the tricky question is, when you look at the rest of Magna Carta, are there outer boundaries on what that's going to be? Now, the examples you mention cause me as a lawyer to think of a different kind of outer boundary, namely that when the government has the power, the raw power to take your property, but it can't do it without compensating you for it. And so we see that in our Fifth Amendment as the takings clause. It's right next to the due process clause, and it really harks back to many other things in Magna Carta, more of these picky provisions that I was talking about, that they were worried about at the time, that, you know, if you're going to take our stuff, you have to pay us for it. Because remember, one of their big gripes against John is that he's taxing them to death for his very ill-advised and poorly conducted foreign wars. So you can't put the entire weight of government on the due process clause for sure, so there are other things too. But I think that the non-arbitrariness idea, the fact that there has to be an external source of law that binds the king as well as it binds everybody else, was really critical.
So first, that was a marvelous speech. Thank you very much. So my question has to do with sovereign immunity. Right? After all, if part of due process, if this history you're tracing from the Magna Carta through the Declaration, through the Constitution, through the way in which we adjudicate various cases, right, rests in some important way on tradition, on convention, on discovering something.
Right.
But somehow sovereign immunity puts the government above that which it claims the rule of law, puts it co-equal with or below. What's the argument for it? There must be a good argument for it. So what's the argument?
You can go all the way back in the U.S. Supreme Court's decisions to one of its earliest decisions, Chisholm against Georgia, which is the case in which a citizen of another state was trying to sue the state of Georgia, a kind of lawsuit absolutely foreseen by Article 3 of the Constitution. It's within the grounds of jurisdiction that Article 3 sets out. And the court split all over the place about whether that was even possible for a citizen to call before to account a state. Because remember, at that time, you almost want to think of the European Union. The concept of the states as of the end of the 18th century is much more one of independent sovereigns who have given up some of their power to the federal government, but insofar as it's not mentioned in the Constitution, they've retained it. And you look at the Supreme Court's decisions throughout the 19th century even, and they're constantly referring to principles of public international law as the rules that govern sovereign state-to-state relations. One of my favorites, Pennoyer versus Neff, being a good example, but there are plenty of cases that say that. So there's Georgia being sued, and most of the members of the court dust off this old idea from England of sovereign immunity derived from a very Stuart-like principle: the king can do no wrong. You know, how can the king in his own courts be called to account? Well, I'm just saying that's one thread of the thought. The other thread of the thought is you bet the king can be called to account, and there were various procedural devices that were used in the English courts to do precisely that, but we didn't carry those procedural devices over, and the Supreme Court decides that the principle of sovereign immunity applies to the states. And then when they think about it further, and this is all judge-made law, there's not a statute on the books that says this has to be the way we do things. It's entirely judge-made. Against the backdrop of the judge-made law, we have the exceptions to sovereign immunity that we now have in the Federal Tort Claims Act and the Tucker Act and the various other places where there are these exceptions. So what's the current justification for it? I think it's weak. I mean, there's a huge literature that looks at this, and a lot of people agree with me that other than just the fact that the government enjoys not having to spend the money, you know, on litigating, and of course who wouldn't, And you wouldn't want the government to be so tied up with litigation that it can't govern, but I find that a very difficult hypothesis to imagine. You have to ask why the solution isn't in creating the right rules of substantive law instead of simply insulating governmental bodies from lawsuits, period. I got especially disturbed myself when the court in the late 90s, this was around 1996, decided a couple of cases about patents and trademarks. These happen to be out of Florida, but they could have been anywhere, in which they said, you know, you can't sue for patent infringement. Indeed, you can't sue a state for anything that involves an exercise of an Article I power, because Article I predates the 11th Amendment, and the 11th Amendment, they say, was designed to restore the concept of state sovereignty that existed at the very beginning. So, you know, they don't have very convincing explanations for why they are clinging to this doctrine that they do. And they don't look carefully. Congress passed a statute in 1976 called the Foreign Sovereign Immunities Act, which sets some understandable lines. As I said, the commercial acts except, and you can sue them for commercial acts, but you can't sue them for governmental acts.
So I wonder if there's a tension between what counts as being sovereign. So if it's an agent, if it's a human being, the King of England is being sovereign, when Hobbes writes Leviathan,
Mm-hmm.
the sovereignty lies in either a single
Right.
individual or a collection of individuals. So if that's one's understanding of sovereign, and it is for Hobbes, then it doesn't even make sense to talk about the law being above the sovereign, because the law is only an expression of the sovereign. But if you decouple the law from the sovereign, and couple it in such a way that the law is exactly what's sovereign, irrespective of the way in which it's achieved, then it looks as if this notion of sovereign immunity is in trouble. So I wonder if there's an historical tension between sovereign as an agent and sovereign as a inorganic group of laws that we find in books that have been described here or there.
No, it's an interesting thought. I mean, of course, it starts with the individual person, you know, the king, the queen, whomever. And you know, even in Britain, of course, we're beyond that, because they have a government at this point with maybe not quite the separation of powers that we do, but now they have their separate Supreme Court of the UK, they've got Parliament, they've got agencies. It is a hard leap. I think that's an interesting way of looking at it.
Thank you, Judge Wood. I have a question, might be related to due process. And I read a book by Kassenstein and Richard Thaler. They talk about libertarian paternalism. And one example is about automatic enrollment. For example, like organ donation, that they have a somewhat brilliant idea that every time a person renews their driving license, there is a compulsory procedure that they have to tick the box whether they would be enrolled automatically of organ donation or not. So what is your take on this kind of nudging or libertarian paternalism, somewhat oxymoron as well?
Well, it really depends on which theory of substantive due process you follow, because if the default rule, if you don't put anything on the back of your driver's license and that's understood as a no, I don't think there's any problem. If doing nothing is understood as a yes, then some people might have religious objections to the organ donation. Some people might have non-religious but personal autonomy objections to it. Maybe they just don't like the idea and they feel like this is part of me. It's part of my bodily integrity. That actually takes you rather quickly to the same debates that happen over contraception and over abortion. They wind up being, to some people's mind, debates about bodily integrity and one's control over one's fate. So I haven't seen a case where any state dared go so far as to say that the default is yes, that if you don't tick the box on your driver's license, then if you happen to be in a fatal accident, they can take whatever they want to take. I would be very surprised to see that law, and I'll just say to balance it on the other side, somebody like Justice Scalia would argue to you that we don't need substantive due process at all because we can trust the legislature not to pass these offensive laws, a law like that. The legislature is going to say we're not going to make yes the default. I'm not so sure of that since I've seen a number of those laws, like the one I mentioned about the grandmother, Moore versus City of East Cleveland is the name of the case. And that was actually a law where the woman was criminally prosecuted for what she did. So the democratic process is going to work a lot of the time, but in some ways the courts sit for those times that it doesn't work. And you need to see if there's some law, and there may not be, but if there is some law that would give you some sort of redress. So.
Good afternoon. Judge Wood, thank you very much, first of all, for the talk this afternoon. Although my accent might not reflect it, I'm a qualified English solicitor, and I've practiced there for about 10 years. I found the American perspective quite intriguing, to say the least. My question relates to contemporary English thought on this matter. Albert Dicey, the English theorist,
Familiar with him? Yeah.
Makes it clear that there's a distinct elusiveness of due process in the current body of English law. We rely rather on natural justice and the rule of law. If there is a erosion or a continued erosion of due process, should their focus not now shift to natural justice as a mediator to ensure that equity is dispensed?
Well, it's a good question. You would have seen in U.S. judicial decisions toward the end of the 19th century and the first decade or two of the 20th century references to natural justice, references to natural law. When the legal realism movement really swept the stage in the U.S., which would have been the 20s, 30s, and forward, people, particularly Holmes and others, derided the idea that there was anything concrete that you could think of as natural justice, and I'm aware, or natural law, and I'm aware that others would have said, of course there is, but that was the prevailing view, that there wasn't anything concrete enough there. So I think Americans don't come from a tradition of legal thought that would be as comfortable relabeling this natural justice. Now, maybe in some ways that's what it is. I mean, the idea that there are some areas that the state is simply structurally and fundamentally not entitled to speak is the idea that is captured by substantive due process. And most people, well, and some people say it's also captured in the Ninth Amendment, by the way. I should probably mention the Ninth Amendment earlier to the Constitution. But I think it's more intellectually compatible with the tradition in the UK than it is here to think of rule of law and natural law than it is in the US. Maybe that's
I'll ask it.
Okay.
You presented the Magna Carta as what you called a seed of the idea of due process. What do you see as the seed of the seed? What sort of resources were they drawing upon when they came up with their pre-version of due process?
Well, yeah, I mean, there are antecedents, as I said, to the Magna Carta. First of all, there's like a charter of the barons, and there are other things. I don't know enough English history to give you probably a really good answer to that, but I do think that somehow in England, by the time the barons are getting together, they, probably because John is in such a weak position, they feel that they can support their own views with this charter, and they're not doing it by picking a different king or something. It's an interesting methodology they have. They're trying to bring this king to reign. And so we'll, you know, I can't really say beyond that to say that that they've already begun to develop, even by 1215, not very long after the conquest, for example. You can go back to the courts of the hundreds. Actually, if you go back to Anglo-Saxon law, there was a tradition of self-governance as well. So maybe it does come from English history.
With that, would you join me in thanking Judge Wood?
And thank you all very much for coming. And we'll be having other lectures soon enough, and a